What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today, another trial starts. Lori Vallow's opening statements, where she is charged in the death of her former husband, Charles Vallow. State goes first. Defense, who is Lori Vallow representing Lori Vallow, goes second. I can't believe what I heard, but I can't say I'm surprised. So let's get into exactly what happened in the opening statements of this case. So the first thing we're going to talk about is the state's opening statement. They have the burden of proof. They have to go first. And if I could just give a little brief thought of how I felt about the state's opening, it was incredibly powerful, incredibly strong, well organized. If I was going to ever give a tip to a prosecutor who's trying a case against a pro se defendant, because not a ton of prosecutors have, it doesn't happen very often. I happened to try a case against a pro se defendant in misdemeanor court. Not a huge deal, but incredibly difficult just because it was a pro se defendant, a guy representing himself, and he had already represented himself on another trial and won against another lawyer at our state attorney's office. So all of our bosses took it very seriously. Me and another state attorney tried the case, and we were successful, and put him in jail for a misdemeanor because of all of the problems that he had started, all the lies that he had told, and just kind of how it went throughout the trial and how miserable it was really quite an experience, and so different than just a regular case. So my advice would to be confident, but not cocky, organized, and keep a structure and make sure there's a method and a reason to everything you do. I'm a weirdly big smell guy, and not just that I like good smells, but I despise bad smells, which is why I loved trying Scentbird. It is a monthly subscription to perfumes and colognes, and they have tons. And you can get different 30-day supplies to try out a bunch of different, which is exactly what I would recommend. Because I tried out a bunch of different ones, and all of them smelled good, but some of them smelled amazing. There are sometimes different scents, right, that you want to wear to the office or to the courtroom versus if you go out to a nice dinner with your wife or you go somewhere with family. I always want to smell good because I hate bad smells, like I said. So it was really cool to be able to try all these different things. And they come in like these little bottles, which is cool. This one is a binaural super solid is what this one's called. And it's cool. They give you this card, especially the first couple times before you know what you want. And it tells you what's in it, right? Mandarin, lavender, labdanium, ambroxan, and amber. Now, if you're like me and you're not a smell necessarily connoisseur, you might not know what all those combinations sound like together. There are some I know I love the smell. And then obviously I love other effects of lavender. But my favorite is this Ex Nihilo Blue Talisman. It smells amazing. This is my number one go-to. My wife absolutely loves it. So this one has a combo of pear, orange blossom, Akagala wood, Ambro Fix. If you're interested in trying Scentbird, scan this QR code right here or use the link below. And with my coupon code LAWYER, you'll get 55% off at Scentbird. Plus, you'll get free delivery to your door and a free case. You get the product for half the price. So that's just $8. That's a steal. It is so worth trying. I'm telling you, if you love it, you'll continue to do it. So the keep it simple, stupid is always something you try to do in every trial, but even more so against a pro se defendant. You're not going to be tripped up by objections and surprise evidence coming in that's really going to hurt your case or anything like that. What you can get tripped up by is getting into the mud and fighting with them, right? And then from a distance, people can't tell who's a pig and who's not. Or arguing with a fool from a distance, people can't tell who's who. So you have to be careful to avoid that and almost just do your job and don't worry about what they're doing to a certain extent, right? The judge is going to help you keep them in line, make sure they're following the rules of evidence. We'll see how this case goes, but you have to focus on what you need to do. Keep it simple, stay organized, and be very confident and authoritative in what you say. Tell the jury, this is the truth. They're going to put on a show here, but this is the truth. You should trust me. You should believe me. Here's all the evidence points. All the cops are with me. All the witnesses are with me. All the victims are with me. You should believe me. That's kind of what should be in your mindset as you're talking to the jury as a prosecutor. And from my perspective, she did an amazing job with the opening statement. It wasn't a big dog and pony show. It wasn't smoke and mirrors. It was methodical, and she went through the story. Now, when listening to her opening, the jury might be surprised when eventually they hear this was initially ruled self-defense and arrests were not made initially. We'll see if and how Lori Vallow can develop that evidence and develop and tell the story the same way the cops initially thought the case went. So that's another important factor that was not mentioned by the state. It was not, if it was mentioned, it wasn't dug into very much, I should say. I don't remember if it was mentioned or not, but I don't think it was mentioned. I don't remember it being mentioned. And if it was, they didn't go too hard at it. Now, they did say, Lori Vallow said it was self-defense. They staged it so that it was self-defense, and they put forth a story that said it was self-defense. I don't remember if she actually took the step to say that's what the cops thought it was initially. But that's going to be a big part of this case. How much can Lori Vallow explain it to maybe think, make the jury think, oh, the state's trying to trick you, but you should believe what the cops thought at first, which was the truth, that this was just in fact self-defense. So let's listen to the first little bit of the state's opening. We're going to kind of listen to the beginning and the end, and I'll summarize the middle and some of the details. We're going to hear so much of this come out in evidence.
So I'm going to need you to stay close to me the next couple days. Mel, too. She can't go to Utah. They're planking some kind of intervention, but want Mel out of the way, so I'm left alone. I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thanks for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. Lori Daybell, the woman seated over here, wrote this to her brother, Alex Cox, on July 9th of 2019, 2 days before they killed Charles Vallow. But to understand why this is so meaningful, why this is relevant, you have to understand the context. So let's talk about it. In July of 2019, Lori Vallow was married to Charles Vallow.
And if anybody's wondering, usually I like when lawyers walk around the courtroom, keep the jury's attention. I feel like if you move, the jury's eyes move with you if they're paying attention. It's a good way to stay locked in. She is limited because it's a pro se defendant, because Lori Vallow is going to be limited to the podium. The state is also limited to the podium, so we can't hold that against her. And she is keeping good eye contact, even though she clearly has notes. I'm not one that says no notes is the only way to do it. It's not fake. This isn't mock trial. You need notes to make sure you hit everything you can, but you have to make sure you keep eye contact. You have to make sure you keep engagement with the jury. Make sure you know what you're talking about and telling an engaging enough story that is a story and you're not reading a book, so that the jury stays engaged.
Lori Vallow lived here in Arizona, Chandler. Charles Vallow lived in Texas. In July of 2019, Lori Daybell was Lori Vallow, married to Charles Vallow. In July of 2019, Lori Vallow wanted to be Lori Daybell.
And that, how she uses her name, it was a little slip up there, but she uses her name throughout. And even at the end, I think we're going to hear a little part of it, but Lori Vallow Daybell, that's her name. Lori Vallow at the time wanted to be Lori Daybell. The motive is as clear as day. Frankly, the motive is the best evidence in this case. They have timing, they have text messages, they have opportunity, they have where they all are, they have how the story was told. They have a lot of things we're going to talk about. But the motive that she was having an affair and wanted Charles Vallow's money is here's balloons for no apparent reason, but it's a motive as old as time. This is the most prototypical motive you can have, or combination of motives, I should say.
Wife of Chad Daybell. And in July of 2019, Lori Vallow wanted to keep the same lifestyle that she had with Charles. And she could get all of this if Charles was dead. She could marry Chad Daybell and become Lori Daybell. She would get $1 million life insurance policy from Charles Vallow. She would get Social Security for herself and their son, JJ, as a child of a dead spouse. And all of this would be true if Charles Vallow was dead. So what about Nephi? Well, Lori Vallow, Chad Daybell, and Alex Cox all believed that those who disagreed with them were dark, possessed by evil spirits, sometimes called Z's or zombies.
No surprise there. She goes into the dark stuff, the weird text messages that I'm sure she's going to read a lot of. She does read some of them. Nephi, who, basically as a parallel to what they did. And that's why they call themselves Nephi. And she told Alex Cox to keep his gun and stay close because they were going to be Nephi and end Charles Vallow's life, but not Charles Vallow, the evil spirit that was inside him. Gets into a lot of that and the weirdness. And she does a lot of different things, which I like. There's a lot of different types of evidence and a lot of different types of things she's going to point to in Lori Vallow's case. And she laid it all out there, right? We have motive, clear as day. We have opportunity. We have intent on why they would want to do it. We have strange behavior, right? And attaching that to religion. We have witnesses that are going to testify that Alex Cox said he wanted to kill Charles, that Lori said she was drugging Charles and putting JJ's pills in his protein shakes. We have a person that Charles Vallow, the day before he was killed, was dating from like a dating app, who's going to testify. Charles Vallow told her about all the weird stuff and strange stuff that was going on with Lori Vallow. We have Adam Cox, who is going to testify that he was texting with Charles Vallow, that Lori Vallow and Alex Cox were planning something, and Charles Vallow knew that. We're going to have witnesses that testify that everybody kind of knew something strange was going on, including Lori and Alex. If you look at their text message, it definitely is something nefarious, a dark cloud hanging over. And they even specifically say they have to get rid of Ned. And it's very clear who Ned is. And he has other names as well. They have evidence of the motive, right? They have evidence that Charles Vallow did something really huge in his life, changing the beneficiary of his $1 million life insurance policy to his sister, Kay Woodcock. That's obviously a big deal. Lori Vallow didn't know about it. Those are all incredibly important. And then they have text messages. They have witness statements. They have text messages. And then they have statements from Lori Vallow and Alex Cox themselves. And how the day this all happened, it was planned. Lori Vallow was there. Then she left. Alex Cox had time to stage the scene, and he had made way too many mistakes. Charles Vallow's left-handed. He put the bat in somewhere where it would have been in somebody that had the right hand. Charles Vallow was a minor league baseball player or semi-pro baseball player, yet we're supposed to believe he hit Alex Cox in the head, and Alex Cox was still able to respond. How the shots happened in the front, out the back, and then the second shot happened when Charles Vallow was on the ground, and how all the evidence will point to that. How there was blood on Charles Vallow's hand because he went to grab where he was shot, but no blood from Alex Cox's head wound from where he got hit in the head with the bat, and how just none of that is going to line up. So they have the crime scene evidence that's not going to line up with them. So again, you have all these different types of evidence: witness statements, text messages, crime scene evidence, medical examiner, statements made by Lori and Alex themselves. How the timeline lines up, that they waited 47 minutes to call 911, and they had multiple calls with each other after the shooting before calling 911. Does that make sense? It all looks like a setup, a cover-up, a staging, and the motive is there. It's locked in. It's about as obvious of a motive as you could ever have in a case. There's also other details, like Lori had Charles's phone, wouldn't give it back to him, didn't tell the cops. The cops thought Lori didn't know Charles got shot, but she did. Just so many strange things that would never happen. Calls to the insurance company, text messages with Chad Daybell. Oh, I guess he must have switched over. The life insurance beneficiary must have been Ned. Just all those conversations that just look really, really horribly bad if, in fact, a crime was not committed here. And I think the testament to this prosecutor's organization came when she was able to summarize the opening statement was about 45 minutes, which I think is about the perfect time for an opening statement. You don't want to go 2 hours. Sometimes 20, 30 minutes can be too short. She went about 45 minutes, but the last 3 minutes, she was basically able to summarize and give an overview of the case again and explain this to the jury in a bite-sized manner that I think is an incredibly perfect way to send them off to lunch, because they went off to lunch right after this opening statement. So let's take a listen to that here.
After Lori found out that she was not the beneficiary, she was so angry that she actually went through Charles's laptop, found the beneficiary change form, sent photos of that to Chad.
So we're going to listen to a little bit more than the last 3 minutes because I don't have the perfect timestamp. But once it gets to the summary, you'll tell and I'll point it out and you'll see she's able to hit this in like 3 minutes. And that shows she's organized. She knows this case. It was a speedy trial. It was pushed. Lori Vallow could have continued. The prosecutor probably would have been fine with continuing it, but she's ready. You can tell.
She also confronted Kay about it. The $1 million she had expected to get was gone. But as Lori told Chad on the 18th, she was still going to get money from the death of Charles. Lori knew already that a month before going to see Social Security, how much money she would get for JJ and for herself as a caregiver as a result of Charles being killed. $4,000 a month. Ladies and gentlemen, the evidence in this case.
All right, here it is, I believe. Here is now the summary of her entire opening statement in just a couple minutes.
It's going to show you that Lori Vallow, Daybell, conspired with her brother.
Lori Vallow, Daybell, and a prosecutor may have, actually, I'm not a prosecutor, a criminal defense attorney, I was going to say may have objected and said just call her X, Y, or Z, but realistically, if that's her legal name, the state is allowed to call her that, number one. Number two, Lori Vallow probably wants to be called that, right? She probably thinks that is exactly what she should be called, but I think to this jury, it says a lot that she ended up marrying the guy she was cheating on her husband with, and Charles Vallow found out about it and talked to Lori and tried to talk to Chad's wife. She brought that up in the opening as well, but she calls her Lori Vallow Daybell, and I don't know if that pause is intentional or not, but I think it's a good pause because it tells the jury her former husband, and Lori keeps calling him her husband in front of the judge. We'll see if she does that in front of the jury too, but Lori Vallow Daybell, because she wanted to be Lori Vallow Daybell, she made it happen. Alex Cox helped her happen, and the only way they could make it happen was getting rid of Charles Vallow, and that's exactly what they did. So I think that pause, whether intentional or not, it's effective.
Alex Cox to kill her husband, Charles Vallow. When Charles let Lori know he was coming into town, she quickly got the pieces into place. Alex came to her house with a gun. Lori created the way to keep Charles inside the house so that Alex and she could be like Nephi. To kill Charles Vallow to better at least her life so she could be with Chad and she could live off that life insurance policy. As we go through this trial, you will see photos of Charles's injury, photos of the crime scene, and hear testimony that will prove that this was not self-defense. As we go through this trial, you'll be provided with phone calls, emails, text messages, and hear testimony that lays out the motive for this murder, money, and Chad Daybell. You will see text messages and hear from people who Lori trusted and who were later pushed away, people who really don't want to be part of this trial, but were pulled into it by this defendant and her desire.
And that's another good point, right? And she's mentioning all the different types of evidence, photos, text messages, witness statements. But a lot of these witnesses wanted to have nothing to do with this trial, but they're pulled into it because of Lori Vallow. They're not interested witnesses. They don't have something out to get Lori Vallow. I think the state thinks that's what Lori Vallow is going to try to do. But like I said, when you're going up against a pro se defendant, you don't really worry so much about what they're going to do. You plan your case, you make it simple, you make it clean, you put it together, you don't over-try the case, you do what is necessary and only what is necessary.
Desire to get rid of Charles to be with Chad. People who heard Lori for months saying Charles was gone, possessed. People who will establish that this murder was premeditated. You will hear text messages from July 9th by Lori to her brother, Alex Cox, that he had to stay near her, that it was all coming to a head, and she would be like Nephi, and so would he. A justified killing, just like the prophet. And later, the text message to Chad where she told him that Charles changed the life insurance policy before they got rid of Ned. A confession by Lori of how religion and money were twisted to justify Charles's murder. At the end of this trial, the state will come to you and ask you to hold the defendant responsible for the death of Charles Vallow and find her guilty of conspiracy to commit first-degree murder. Thank you.
Short, sweet, pretty simple. Now, again, not the most engaging opening statement. Not going to have people coming out of their chairs, but a pretty shocking story if you didn't know anything about this, right? Some very strange things. There's some intrigue because was it self-defense? Was it not? There's a lot of different characters that were introduced, so you don't want to overcomplicate it. So yeah, it could have been a little bit more engaging, but I thought it was really, really good. I thought it was organized, like I said, and I love pointing out all the evidence you have. I've got text messages, I've got witness statements, I've got pictures, I've got medical examiners, experts, cops, everybody. So what does she have, right? You load it all up and you don't even know what's happening to you if you're the jury, but you're thinking in your head, this is a mountain. They are putting together a mountain of evidence, which is what you need to do to get to proof beyond a reasonable doubt. But she's presumed innocent. So what does Lori Vallow have to say in her very first, it's an opening statement, but we may call it an argument here in front of this jury. Oh boy, this is what we're here for. We're going to listen to the entirety of Lori Vallow's opening statement now. I expected it to be an argument. Let's see if I was right. And by the way, just a little disclaimer, I recorded that entire part one with the state's opening before listening to Lori Vallow's opening. So any guesses I had or things that I thought she may argue, may not argue, may be able to argue, may not be able to argue, was all said before actually watching her opening statement. So let's take a listen to it together. I literally can't wait.
Ladies and gentlemen of the jury, I have been charged with a crime, a serious crime. And the only question here is, did I commit this crime? Conspiracy. Conspiracy is an agreement between two or more people to commit a crime. Okay, so you see here. Okay.
Just getting a little help from people around the courtroom. I'm not sure if that was her paralegal or standby counsel or somebody in the courtroom, but you can expect to see her get some help. Doesn't skip a beat, just keeps going. She doesn't sound nervous. Somebody in her position, I can understand why they wouldn't be nervous. She's already got the worst of the worst at this point. So it's not even like even if she wins this case, her life is going to change all that much. But we will see if she continues that poise throughout the entirety of the opening. Some other things I was looking for is she going to be manipulative? Is she going to say what happened and explain what happened in a way that she has to testify? Is she going to leave it open to where maybe she won't testify? Those are some of the big questions whenever you have a pro se litigant.
There has to be an agreement. There has to be a plan. The evidence in this case will show that Charles Vallow and I got married in February 2006.
Sorry, another thing I want to point out is she starts out basically arguing the law. This is conspiracy. There has to be an agreement. There has to be a plan. All of that, to me, points towards arguing the law, that she's going to go, we didn't agree on anything. There was no plan. Even if you say this shooting was intentional by Alex Cox, let's say, I didn't have anything to do with it. There was no agreement or plan by me, which is a way a defense attorney would probably argue this case is it was self-defense first, but if it wasn't self-defense, Alex Cox did this, not Lori Vallow.
It will show that it was my fourth marriage and Charles' third marriage. At that time, we each had 2 children. I had Colby, who was 9, and Tylee, who was 3. Charles had Cole, who was also 9, and Zach, who was 7. The evidence will show that our family moved from Austin, Texas to Chandler, Arizona in 2009. The evidence will show that Charles and I adopted our great-nephew, JJ, who was born in 2012. It will also show that Charles and I were married for over 13 years and were raising 5 children. The evidence will show that I was a licensed cosmetologist and worked as a hairstylist for 20 years while we lived in Austin, Texas. The evidence will show that Charles was a licensed life insurance salesman and worked as an independent contractor, selling life insurance policies and annuities, and owned his own business.
So she's giving their background, not unusual. A couple things that just come to my mind. How is she going to get this information? How long they were married, what they did for a living, when they moved from here to there. There's not that many people alive still that could testify to that, right? Now, starting to think maybe she's going to testify herself. She could obviously testify to all of that. Or another way a defense lawyer could get it out is cross-examination. Her sister may testify. Other family members of hers may testify that may or may not be friendly with her that could still answer a lot of these questions and give the background of Charles Vallow and Lori Vallow. That still remains to be seen. So far, there are other people that could testify about some of this, but the way she's setting it out, maybe we're starting to look towards her testifying.
The evidence will show that Charles and I purchased life insurance policies early in our marriage, and Charles had them issued to the maximum amount possible to each of us. The evidence will
Also important to point out, this was Charles' expertise, life insurance. It's what he did, and he always did it a certain way to have the maximum amount for each of them always available. I think it's smart, right? Because you hear $1 million, maybe she took out $1 million before planning to do this. No, it wasn't like that. This was his job. He would shop them around. We would always have the max. It was nothing weird. For 13 years, we had this type of insurance. Is, the story that she's telling. This was very normal. This was not nefarious. He had one on me that was even more money. I think it's actually a good way to set out the facts.
will show that Charles was 17 years older than me. And that because of Charles' age and an issue that he had with high blood pressure, the maximum amount of life insurance that could be approved for Charles was $1 million. The maximum amount of life insurance that I could be approved for because of my age and my health was $2 million. The evidence will show that throughout our 13-year marriage, that we always had life insurance policies. When a 10-year policy lapsed, Charles would shop for another company who would approve us for the maximum amount of life insurance. The evidence will show that this was Charles' job. This is what he did. I helped him in this business, and this is what he did. The evidence will show that in 2016, Charles repurchased a new $2 million life insurance policy on me, and he was the sole beneficiary. The evidence will show that.
Therefore, being the sole beneficiary on a life insurance policy is not A, abnormal, and B, it's not motive to kill. Obviously, it can be, but she's trying to normalize it, which I don't think is a bad strategy.
Charles and I had a happy marriage for 13 years. That he was, in fact, a baseball player, and that he played high school, college ball, and AAA ball, and that he was, in fact, a left-handed pitcher, a southpaw, they call him, but he was a right-handed batter.
So she's contradicting the state's evidence. And I think, I don't know if she's right or wrong, right? I'm sure we'll have people testify to that. There's going to be family members testifying, but that's important. If she's right and the state's wrong, she can actually build credibility. Now, if she's wrong, I already think it's an incredibly uphill battle because of what's going to come out during this trial, that the jury's probably not going to believe her and she's not going to have a lot of credibility. But if they start spitting facts that are in exact opposition and she ends up being right and the state ends up being wrong, that could be huge for Lori Vallow.
Could be attested to by anybody who knew Charles well and his high school baseball coach, Greg Davis.
She's like, it's obvious. And she mentions his high school baseball coach, Greg Davis. Will he be testifying? Will she be calling him? Or is she just doing what sometimes pro se defendants do and say, this is so obvious, this person, that person, all these people could testify to it, but the jury never actually hears about it. I also wanted to mention, before openings even started, the judge reminded the jury that nothing that is said in opening statements is evidence. The evidence comes from the witness stand and the documents and things that are entered into evidence as exhibits for you, not what the lawyers or what Lori Vallow says from the podium, only what she says from the witness stand if she takes it.
The evidence will show that Tylee was, and in 2014, our family moved from Chandler, Arizona to Kauai, Hawaii. We lived there for 3.5 years and returned to Chandler in 2017. The evidence will show that Tylee was 3 years old when Charles and I got married, and that when she became a teenager, the relationship between Tylee and her stepfather, Charles, became so difficult that Tylee and Charles had to seek a therapist, a family therapist.
So who's going to testify to this? Think that question in your brain. Every time you hear her say something, who's going to testify to this? Is she going to call a witness, or is she going to be able to get it out on cross, or is she going to have to testify? Because now we're wading into even more waters because Tylee is unavailable. Lori Vallow tried to argue she's unavailable, so I should be able to get into her hearsay. The state's like, she's unavailable because you made her unavailable. And the judge is not going to give Lori Vallow any benefits by the fact that Tylee Vallow is not here. And from my perspective, as we look at this case, this is where it really starts to get cringy, because when the jury hears Lori Vallow talk about Tylee and JJ, what do they know? What are they going to find out? And then what are they going to think? If it's just a mom talking about their kids, that's one thing, right? But we know the real story. We know what really happened. So there's almost two ways to look at this. If I knew nothing, I actually think so far it's going okay, how she's discussing the facts. But what I know, it's getting disgusting and it's going to get worse. So how is each individual juror going to look at this? And let me know how you're looking at this as you listen to her describe it in the chat.
stop them from fighting. The evidence will show that together, Charles and Tylee met with this therapist after we moved back to the mainland in 2017. The evidence will show that in April of 2018, Tylee's biological father passed away from a heart attack. And at that time, Charles called Social Security and made an appointment at the Social
I'm
Security
going to
office.
object to hearsay.
Sustained.
There will be a few objections. I think every single one of them are sustained. I think the state did a good job of composing themselves and not objecting every time they could have, argumentative and things like that, which they could have. They didn't, but there are some very, very key facts. Lori Vallow tries to slip in, one of them being Charles Vallow went to the Social Security office and did X, Y, and Z. The objection, hearsay, you can't get into that. You weren't there, so you don't know what he did or what was said. She still gets into some of it, which again, kind of like a lawyer, if you lose on an objection, you try to find another way to say it, which she does right here the best that she can. But a good job by the state, only objecting when absolutely necessary.
It will show that we did get Social Security for Tylee for her deceased father until she was 18 years old, and she was 15 years old at the time. The evidence will show that Charles and Tylee's fighting increased greatly in January of 2019 when Charles and I temporarily separated. The evidence will show that several people witnessed these terrible arguments between Tylee and Charles that increased to physical in 2019.
Disagreements between Charles and Tylee turned physical. What do you think a jury's going to think about that? Right? She's trying to turn Charles Vallow into an unsympathetic victim if he got physical with their daughter who is a teenager. How true is that? How is she going to be able to prove that? Who knows? We'll see. But as far as giving the jury something to chew on and something to think about, she's definitely doing it. Now, is it all going to explode when it turns out to not be quite the way she explains this entire story? Probably, but we're judging an opening statement at this point.
Charles and Tylee had major increasing arguments, two in February of 2019, one of March in 2019, which was captured on video, one in May of 2019, one in June of 2019, and then the worst of all in July 2019.
Which is when this happened. So she's looking at the jury and saying it wasn't good between Tylee and Charles.
The evidence will show that in March of 2019, Charles pulled JJ out of his special school and moved him to Houston, Texas.
Again, unsympathetic victim. This jerk pulled JJ out of his special school that he needed and loved. She didn't quite go that far, and took him to Texas. That's what she's trying to build, is that Charles is not a sympathetic victim. That I believe is what she's trying to build with a lot of these facts.
While we were
And then I point out the elephant in the room, saying the evidence will show every time is supposed to get you over objections. Somebody clearly told her that. Maybe she watched a video on it. I don't know. It's kind of like what you tell first-year mock trial students is if you're not sure, just say the evidence will show and you can slip some argument in. She's basically saying it before every single thing she says. Maybe that's what her standby counsel or paralegal or somebody told her. She's clearly trying to do it that way.
Rarely separated. Tylee and I then joined Charles and JJ in Texas in April 2019 to reconcile. The evidence will show that JJ was diagnosed with severe autism when he was 3 years old while we lived in Hawaii. The evidence will show that for 2 years, JJ was attending a school in Gilbert, Arizona, a special school for children with autism. It's called Lauren's Life Academy.
And again, it's like, wow, this is very, sad that they're fighting about this and they have a child with special needs and Charles is taking him away from his school. And Lori, the mom, seems like she really cares about him and wants him to be in that special needs school. So if I'm thinking about it from that brain where I don't really know what happened as a juror, I'm starting to feel for her, right? But if you know the truth, oof.
The evidence will show that in June of 2019, in JJ's best interest, Tylee, JJ, and I moved back to Chandler, Arizona to re-enroll JJ back in Lauren's Life Academy since he had a difficult time with the Houston, Texas schools with no services for his autism. The evidence will show that Charles and I agreed it was in JJ's best interest to be in school where more services were available to him. So Charles and I rented a house here in Chandler. On the day in question, July 11th, 2019, Charles and I were renting two houses, one in Houston, Texas, where he mainly resided, and one in Chandler, Arizona, where I resided with our two minor children, Tylee and JJ. By this time, our three older boys, Colby, Cole, and Zach, were adults and not living at home any longer. The evidence will show that during the months of June and July, that my husband, Charles Vallow, began to send me threatening text messages. These messages were seen by my sister Summer, and that worried her.
So again, I'm thinking, is Lori Vallow going to have to testify about those? Will Summer testify about those? Are any of these witnesses going to be friendly towards Lori Vallow? Because she's going to be able to get into all of these facts if she testifies herself. But if she doesn't, and she doesn't ask the right questions, and these witnesses don't get these facts in, she's not going to be able to argue them again in closing. That's the difference between opening and closing. Opening is a roadmap, what you expect to happen. Closing is using only what came in at trial and, of course, the inferences that are reasonable from the evidence that came in at trial. So two very different things. Right now, even though usually opening is seen as more limited because you can't argue, it's the wild, wild west as far as facts for a pro se defendant. But then in closing, if it doesn't come in, objection, facts on evidence, objection, facts on evidence, you cannot argue those facts because nobody testified to them. Wink, wink, meaning you didn't testify to them.
The evidence will show that Charles insisted on flying into Phoenix on July 10th, as we've heard from the state. The evidence will show that I advised Charles that he could not stay with us at the Chandler house because he could not get along with Tylee, and I did not want them to get into another fight like they had 3 weeks prior.
So that's an interesting fact that can be seen two ways. Lori Vallow is going to argue, I didn't want him there. Tylee didn't want him there. He insisted. He forced his way there. Does that sound like we made the plan? Does that sound like we wanted to do it, that we enticed him to come, that we tricked him and trapped him into coming into this house, that nobody wanted him there? There was no conspiracy. There was no agreement. If, again, you're trying to help her out with where she's going.
The evidence will show that it was ultimately decided between Charles and I on text messages that he would stay in a hotel because he traveled for business all the time and stayed in hotels all the time, and that I would book it for him since I worked for him and booked all of his travel. The evidence will show that Charles did in fact fly into Phoenix on Wednesday, July 10th, and stayed in the hotel that I booked for him. The evidence will show that Charles paid to fly my brother Adam Cox into Phoenix from Kansas on the same day, Wednesday, July 10th, 2019. The evidence will show that Charles planned to come to our Chandler home and pick up JJ and drive him to school on Thursday morning, July 11th, 2019. The evidence will also show you that Lauren's Life Academy opens its gates at 8:25 a.m. in the morning. And the evidence will show that Charles showed up at our Chandler residence around 7:30 in the rental car I booked for him on the morning of Thursday, July 11th, 2019. The evidence will show that Charles began texting with my brother, Adam Cox, before he entered our residence, and that Charles and Adam were discussing in their text communications that my other brother, Alex Cox, was at the residence. The evidence will show that on the morning of July 11th, that Tylee was asleep in her room and my brother Alex was asleep in the guest room. The evidence will show that when
Again, everybody's sleeping in the house, not planning on doing this. No plan here. That's what she's trying to argue.
Charles entered the house, only JJ and I were awake and present. The evidence will show that after we put JJ in the rental car, that Charles came back into the residence to receive his phone, leaving JJ in the front seat of the rental car with the engine running. He was 7 years old. The evidence will show that Charles began to scream at me when I refused to hand him his phone. The evidence will.
So who's going to testify to all of this now? That's what you need to think about. Because Tylee, Charles, and Alex, and even JJ, who she says was in the car, are all gone. Out of the way, some would say. Everybody around Lori Vallow and everybody in her life dies unless your name's Chad Daybell, basically. Or if you're an adult male and you can defend yourself at least like Colby, her son. It's, again, this is two completely different ways to look at an opening statement. It is the absolute most cringy opening statement I've ever seen when you know what actually happened and what's the truth and what the facts are in her life and what happened even after this incident. But the other way, maybe she's not doing so bad. If you have no clue what's going on, seems like a good mom who cared about her kids, that was in a bad relationship with an angry, violent guy, Charles Vallow. Her brother is there just to protect her and her daughter. But who's going to testify to all these facts? That day, what happened?
Will show that Charles screaming woke up Tylee and Alex. The evidence will show that Tylee came out of her room with a bat to protect me, her mother, from her stepfather, Charles Vallow.
And now the tears start. And once again, sounds like a really great mom with a great relationship with her daughter who came out to protect her with a bat. Everybody's there to protect Lori Vallow. Tylee, Alex Cox, from Charles Vallow. That's the story she's telling.
The evidence will show that Tylee and Charles fought over the bat, and that after a struggle over the bat, Tylee fell onto the ground, and Charles lifted up the bat to hit Tylee with the bat.
Now, there are recorded statements, I believe, from Lori and Tylee that do explain some of this. I'm not so sure how she's going to get them in, if the judge is going to allow them. But obviously, if she testifies, she can testify to what she observed and went through and saw that day.
The evidence will show that Alex then intervened to protect Tylee from being hit with the bat. He did not have a gun. He was not wearing a shirt. He was pulling up his jeans because he just woke up and came into the room where he heard the screaming.
So again, not a plan number one, and not just self-defense for himself, right? Self-defense for Tylee and for Lori and for himself. That's the story she's building here.
The evidence will show that Alex and Charles got into a physical struggle for the bat and fell onto the ground. The evidence will show that Tylee, who was on the ground, was lifted up by me and sent outside to get away from the struggle and to protect JJ, who was still in the running car, in the rental car in the driveway. The evidence will show that after the struggle on the ground between Charles and Alex, that Charles prevailed with the bat and began to come towards me with the bat as I ran away from him into the kitchen. The evidence will show that at some point while I was running away from Charles, who was chasing me with the bat, that Alex apparently retrieved his gun.
And these scary facts, right? Facts have been told before in some version, right? When they did the initial investigation and ended up determining that this was self-defense. Are there inconsistencies here? Are there things that the state's going to be able to impeach her with? Are there mistakes that were made, like the state said in their opening statement? So is she actually giving more ammunition to the state to prove that she's lying and manipulating here?
The evidence will show that I ran outside to the children and that Alex shot Charles in self-defense. The evidence will show that Tylee and I had both run outside without shoes. The evidence will show that JJ was still in the front seat of the rental car with the engine running and struggling to get out of the car. Tylee was trying to keep him in. The evidence will show that Tylee and I got into the rental car with JJ and drove away. The evidence will show you that I drove the children away from the residence towards JJ's school. Can I grab a tissue?
Yes.
Can I grab a tissue? The waterworks are going. Real, fake, it's for you and the jury to determine. Is she manipulating?
The evidence will show that I drove the children through the Burger King drive-through that Charles had promised JJ. The evidence will show that we continued to drive towards JJ's school and that the gate was not yet open at JJ's school. So we drove a block west of the school to a Walgreens where I ran in to purchase flip-flops for Tylee and myself so that we could walk JJ into school on the hot pavement. The evidence will show that Tylee and I returned directly to our residence where we met with police in our driveway. The evidence will show that we were spoken to by the Chandler police officers. And the evidence will show that Tylee and I were told by the Chandler police detectives that Charles had passed away.
So their story is they didn't know. Well, her story, I should say, is she didn't know Charles had passed away. Chandler police did tell her. State made it seem like otherwise, like she left after and had conversations with Alex Cox. How could she not know? Only one of those things can be true.
The evidence will show that we were put into a police van and driven to the Chandler Police Department. The evidence will show that Alex was taken by police in a police car to the Chandler Police Department, and that we were all three separated into interrogation rooms and we were each interviewed. The evidence will show that next, Tylee and I were brought back together into a room at the Chandler Police Department and were introduced to a victim's advocate who was very kind to us. The evidence will show that after speaking to the victim,
Who's going to testify the victim's advocate was very kind to them? Only Lori Vallow could do that. Now, that's a fact that might not be testified to, that she was able to get in. And that's what you have to think about. How many facts is she sliding in here and able to basically testify during opening statements that if she doesn't testify later, the jury has heard it? Will they be able to parse out what's evidence and what's not? Will the state be able to explain to them effectively so they only take into consideration what comes from the test or from the witness stand? You have to be careful about not holding it against the defendant that they don't testify. It's a very important right, but it gets so muddy when they're able to make multiple arguments to the jury and speak to the jury without taking the stand, which is why you got to tighten up on closing. You may seem like a jerk. You try to not seem like you're bullying the defendant that's going pro se, but you cannot let them just testify in closing arguments. Now, if they get up there and they take the stand, then they pretty much almost have free reign in closing argument.
victim's advocate, that Tylee, Alex, and myself were put back into the police van and driven back to our residence. We were directed by the Chandler detectives to take the rental car and return later to the residence after we picked up JJ from school. The evidence will show that we did as instructed by the Chandler detectives. The evidence will show that we drove to Alex's residence where we attended to the wound on the back of his head. The evidence will show that Alex was then contacted by the Chandler detectives to return to the residence so that Alex could walk them through the events that occurred with the detectives at the residence.
This is really important, right? She's saying, we told everything to the cops. We showed everything to the cops. The cops investigated. They talked to us. They came to the scene. They walked the scene. They looked at the scene.
Evidence will show that Alex, Tylee, and I did return to the residence as instructed. And the evidence will show that Alex entered into the residence with Detective Moffett, but that Tylee and I were met by Detective Inkland in the front yard. The evidence will show that at the time, Detective Inkland asked Tylee and myself if we had Charles' cell phone. Tylee retrieved Charles' cell phone from the rental car and gave it to Detective Inkland at 3:11 p.m. on July 11th, 2019. And at that time, Charles' phone was placed in the custody of Chandler police detectives. The evidence will show that Detective Inkland asked us if we knew the passcode on Charles' phone, which Tylee proceeded to give to Detective Inkland. The evidence will show that Tylee and I left the residence to pick up JJ from school, while Alex remained at the residence with the detectives. The evidence will show that by the time Tylee, JJ, and I returned to the residence, that all police, EMS, CSI, and detectives were gone from the residence and only Alex remained. The evidence will show that the next day, I contacted Chandler Police to inform them that Charles' belongings were still at the hotel. I asked the detective if I should go get them, and I was told that they would take care of it. The evidence will show that
Again, sounds like Lori Vallow's side of the story, right? Will detectives agree with that when they testify? Is that what happened? Or will she have to testify to explain her side?
I asked the detectives, what should we do next? And they directed us that they would contact us in about 3 weeks after their supervisor passed off their reports, and Alex could go to the police station and retrieve his gun. The evidence will show that the last thing I heard from Chandler Police Department until June of 2021, 2 years later, when I received a grand jury indictment from them for this alleged.
This is where I would have objected if I was the state. I'm going to back it up just so you can kind of hear the whole comment she makes.
Chandler Police Department. The evidence will show that the last thing I heard from Chandler Police Department until June of 2021, 2 years later, when I received a grand jury indictment from them for this alleged crime. The evidence will show that Chandler Police treated this incident as self-defense.
I'm going to object to that.
The objection is sustained. The jury should disregard that last statement.
She slips it in there. Jury heard it. Can't unring the bell. Totally inappropriate. Totally unfair. A defense lawyer would be reprimanded by a judge for doing this. But I do think that defense lawyers would develop the way and the theory through the officers that they did believe it was self-defense. I think you can develop it. But the way that she said it and how it came in is not the appropriate way to do it. And I believe, I'm not positive, but I believe the judge already said you can't do that in opening. That's why I think a defense lawyer would get reprimanded. But I do think there are ways to discuss the investigation, discuss what they did, who they spoke to, and how they thought it was self-defense. I think there are absolutely ways to develop that through the trial. But a lot of times you're not allowed to argue that till closing. And I think that that's what they said here. So I'm not positive though, but I think that's what they said here. And obviously the judge sustained that objection. But I think it's a really good fact for Lori Vallow. And I think she laid it out pretty great. Here's everything that happened. They had all the evidence. They talked to everybody. And for 2 years, they said this was self-defense. The cops said this was self-defense. Now, that opens the door to everything else that happened, I think, potentially. There's just so much going on in the background of this case that the judge has a big job on his hands of determining what is going to come in and what's not, and why and how is it all going to come out to make sure that we don't either lie to the jury, mislead the jury, or trick the jury.
The evidence will show you that my brother, Alex Cox, passed away on December 12th, 2019, almost exactly 5 months to the day after Charles, my husband, passed away. The evidence will show that Alex passed away from a blood.
Also, you'll notice she calls him her husband and doesn't mention Chad Daybell, doesn't mention the affair, almost as if none of that even happened or none of that exists.
Clot in his lung.
Objection again.
I'll sustain the objection. It's not relevant for this matter.
I kind of think it is relevant because, I mean, it depends on how much they get into everybody around her dying. If he did die of a blood clot, natural causes, had nothing to do with her, that can become important depending on how all the evidence comes out in this case and what the judge allows and doesn't allow, but sustained at this point.
The evidence will show you that I am the only person being charged with this crime.
I'm going to object to the relevance of that.
Sustained.
As the state has mentioned, they're alleging that insurance money was my motive. Social Security was my motive. Spouses having insurance policies is not a crime. Collecting Social Security is not a crime. Self-defense is not a crime. A family tragedy is not a crime. It's a tragedy. Thank you.
So again, theoretically, you may think that sounds good, but it's like hatred is not a crime. An affair is not a crime. Greed is not a crime. But they're all motives for potential crimes. And if you commit a crime to get that money out of greed, that is a crime. If you commit a crime because you hate somebody and you want to remove them, that is a crime. So yes, just insurance policies on their own or hatred on its own is not a crime. They very well can lead to crimes and be motives for a crime. So while that may have sounded smart as like her punchline, I think that fell flat and was a complete swing and a miss. But I have to say, as far as the presentation goes, about as good as I've seen a pro se defendant do. You guys let me know. We've heard a lot of other pro se defendants make arguments, say things in court. I think this is about as good as she could have done. Now, is a lot of this going to come out as lies? Is a lot of this actually going to come out making her look horrible? I think the answer to that is yes. Is the jury probably going to hate her by the end of this trial? I think probably yes. But at this point, she's presumed innocent. She's made this argument. And yes, I'm calling it an argument at this point to the jury. So how are they feeling at this moment based on what they know? You tell me. Let me know in the chat. Let me know what you think about it. I think I know how you're going to respond to it and react. But those are my initial, honest, just gut reaction thoughts. And I think this trial is going to be wild. I do. I think she is going to do her darndest to play lawyer here. And I don't think she is going to be embarrassingly horrible, but I think she is going to be potentially incredibly cringy and manipulative. And to the people in the background and the victims and the family in this case, it's going to be a very tough watch and listen to them, and probably for a lot of you. But let me know what you guys think in the comments. And hit that like button if you're following this trial and you want more coverage of it. Or if you're not interested, let me know in the comments and maybe we can focus on some other things. But so far, you guys have been interested in this. I've been interested in this. It's a really interesting watch to see how Lori Vallow, I mean, how different from a criminal defendant who went through a very similar trial and did not say a word. And now she's going to be speaking throughout the entire trial. You don't usually get things like this. So whenever there's something incredibly abnormal in the law, we love to cover it, love to discuss it with you, get your questions and thoughts and feelings on it. So I think that's what this is, but you guys let me know if I'm right or wrong. But that's all we got for tonight. Till next time, go Cougs. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.